All right, we're now going to hear next witness is going to be Professor Hirsch. I think we've agreed in advance that Professor Hirsch's testimony is going to be somewhat narrow. Professor, I had you in the courtroom so that you would hear what the parameters of your testimony are going to be. That Professor Hirsch is not going to testify, nor is he going to be asked any questions about as to whether or not the defendant's statement or any particular response to a question is the result of police coercion or improper questioning. He is not going to testify as to any opinion as to whether the defendant or any particular response is truthful or untruthful. That he is not going to testify as to whether or not the defendant is a suggestible individual or is one who is more susceptible to a particular interviewing technique. And he is not going to testify as to the number of false confessions or estimate as to the percentage of interrogations that result in either fake, false, or coerced confessions. I'm sorry, you can be seated. I thought I said that already. Right, Mr. Vickers?
Correct.
Right, Mr. Knippen, Ms. Kraft? I don't know who's taking this
Honor.
witness. Okay, you understand that, Professor?
Could I ask for a few clarifications?
Sure.
Thank you. So I would testify if asked that the statement about her burning the baby was false, that we know it's false. I would not state that that was coerced or produced by any interrogation method, but I would say that we know it's false. That would not go outside your parameters.
That would not go outside my parameters.
That would be okay.
Yes.
And the second question is, I would not testify that she's a suggestible individual. Would I be permitted, if asked, to testify that I've read a report by a psychologist saying she is?
No.
Would not. Okay. Thank you, Your Honor.
Mr. Knippen, something on that?
My concern is when he says that he knows now that this statement to be false about whether the child was burned or not, I don't think is an accurate statement.
Okay. I think that he can say that he has viewed forensic evidence. So what's the question going to be, Mr. Rickers, with regard to this? What would the question be?
On the burning?
Yes.
God, it's deep in my outline. Apologize, Judge, I wasn't expecting to. Were there any comments that the officers made that you found especially problematic?
And as long as he's focused on the questions by the officers, we're on good ground. If he is talking about the responses from Ms. Richardson, we are not on very good ground. Do we agree on that?
Yes, Judge, and my concern is he's making, and this is in his report as well, and I believe that this was probably information provided by defense counsel. He says, and correct me if I'm wrong, but he says, we have a statement that the police told her with respect to the burns that we know demonstrably now is false, that this child was not burned. And I agree that the evidence is such that there's no evidence of burning on the bones themselves, but that does not necessarily mean that the child was not burned.
Okay. I mean, I think the expert is not going to testify as to what that fact is or is not.
Okay.
But he can be asked to assume a fact.
Sure.
Okay?
Okay.
Are we ready for the jury?
The burning was not true. Right?
He is allowed to assume, be asked a question to assume certain facts that may or may not be in dispute are true, and then give an opinion, not as to Ms. Richardson's response, but as to the questions, whether or not that affects his opinion.
Thank you.
Okay? Anything else? All right, go get the jury, and we're going to break at 5:30 because the jury said we're leaving at 5:30. You may be seated. All right, he's right behind you.
Stand and raise your right hand. You solemnly swear or affirm that the testimony you will give in these proceedings to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may be seated.
Your Honor, could I request water? Oh, thank you very much.
You may proceed.
Thank you, Your Honor. Professor Hirsch, could you please state your current position?
I teach law-related courses at Williams College. My title is Instructor in the Humanities, and I'm also chair of the Justice and Law Studies program at Williams College.
For how long have you taught at Williams?
I believe 13 years.
Can you describe for us your educational background?
I received my undergraduate degree from Amherst College in Massachusetts and my law degree from Yale Law School.
While at Yale, did you concentrate on any particular area of the law?
I took a particular interest in the overlap or intersection between law and psychology and studied extensively in that area.
Have you maintained your interest in the overlap of law and psychology
Yes, I have.
and continue to do work in that area?
Yes, I have.
You're not a psychologist.
That's correct.
Are there different kinds of confession experts?
Yes, there are two kinds. There is the mental health professional, typically a clinical psychologist or psychiatrist, who may evaluate a particular defendant to determine whether he or she is susceptible. And then there are experts like myself, typically legal scholars or social psychologists, whose principal expertise is in the interrogation methods that contribute to false confessions. And we have an expertise or an awareness of, knowledge of all aspects of the issue, but we are not mental health professionals and do not evaluate a particular person.
Would you please state some of the law-related work you've done that acquaints you with America's criminal justice system?
After law school, I spent 1 year as a law clerk for a judge on the United States Court of Appeals for the Third Circuit. I then spent 3 years as an attorney/writer at a government agency in Washington called the Federal Judicial Center. Ever since then, most of my law-related work has been teaching and writing about the law and serving as a trial consultant.
Is there a subject you focused on?
In the last 15 years or so, my focus has been on criminal interrogations and confessions.
Have you written on that subject?
Yes, I've written extensively both in legal academic journals as well as mainstream publications such as the Los Angeles Times.
What are the journals that published your scholarly articles on this subject?
Ohio State's Journal of Criminal Law, Berkeley Law School's Journal of Criminal Law, North Dakota's Journal of Law Journal, and Howard's Law Journal.
Have you done anything else related to interrogations and confessions, Professor?
Yes, I started and continued to operate the first website devoted to this subject.
What's the name of your website?
Truth About False Confessions.
And what's on that website?
So there's a lot of material. Some of it is permanent, like frequently asked questions and recommended literature. And then I also post comments or analyses from time to time.
What do you comment on or analyze?
Anything related to the subject. Could be new cases, new articles, new thoughts I've had, new cases I've been involved in, anything that strikes me as relevant.
How many posts have you done?
Certainly many hundreds.
Has your website received any official recognition?
Yes, in 2007, the American Bar Association listed it as in their top 100 law-related websites and listed it first among criminal law-related websites.
You mentioned that you do work as an expert consultant and witness, correct?
That's correct.
How many cases have you been retained in as an expert consultant?
Almost 200.
Have you testified in any of those cases?
I've testified in 33 cases.
Have you ever testified in the state of Ohio?
Yes, I have. I testified at a trial in, I believe, Darke County in 2010.
You mentioned your own scholarship, but how about more broadly? Is there a lot written about false confessions?
There is a voluminous literature. There are analyses of proven false confessions. There are observational studies of interrogations. There are some laboratory experiments. And there's a vast literature I guess I would call miscellaneous. But we're talking about many books and countless articles.
How well acquainted are you of all that
I'm
information?
pretty well acquainted. You have to be in order to contribute to that literature, which I have done.
Does much of this literature on false confessions concern interrogation methods?
Yes, it does. Sorry.
Interrogation methods used by law enforcement.
Yes, it does.
And are those organizations that train people in interrogations and let me strike that. Are there organizations that train people interrogation techniques and produce interrogation manuals that are relied upon by law enforcement?
Yes, there are.
Is there one organization that is particularly influential in that regard?
Yes, there is.
What is it?
Reid and Associates.
And what is the Reid manual called?
Criminal Interrogations and Confessions.
And have you read and studied that manual?
Indeed, I mentioned writing for the Ohio State Journal of Criminal Law. That was a thorough critique of the Reid manual.
Let's turn to the background information about false confessions. Are there different categories of false confessions?
Yes, we break it down into three categories. First, there is the voluntary false confession. This is someone who comes forward outside of an interrogative situation and claims to have committed a crime that it turns out he or she did not. Then there is what we call the coerced compliant false confession. This is someone who, under interrogation pressure, knows he or she is innocent, but concludes that they are best off. It's the only escape from a difficult situation if they confess. And then there is the coerced internalized false confession. These are cases where the suspect actually comes to believe that he or she committed the crime, even though it turns out they did not.
May we approach for 1 second, Judge? I just don't want to do something.
All right, Mr. Rickers, you may continue.
Professor Hirsch, are false confessions common?
Sustained.
Professor Hirsch, how do we know that we have false confessions?
So a lot of that knowledge started when the Innocence Project began testing people for DNA, and hundreds of people were exonerated who had been convicted of crimes. And it turned out that a substantial number of them had confessed. And that led social scientists and legal scholars like myself to begin digging for false confessions. And quite a few proven false confessions have been identified. And we have reason to believe that that number is actually relatively, it's what we call the tip of an iceberg, that there's really...
Sustained. The jury will disregard that last portion of the answer with regard to how many false confessions might be around.
Doctor, when you mention a risky approach to interrogation, are you referring to the Reid method?
Yes.
Can you summarize for the ladies and gentlemen of the jury what the Reid method is all about?
So technically there are 9 steps, but it really consists of 2 essential steps. First, the interrogator expresses absolute certainty of the suspect's guilt. They communicate to them, we know you're guilty, nothing you say will convince us otherwise, and they cut off any denials or protestations of innocence. Having scared the suspect like that, they then do various things which we call minimizing the crime. These are various ways of suggesting or even explicitly telling the defendant that if you confess, it won't be that bad. It may be that your role was secondary, or there were mitigating circumstances, or there are a great number of minimization techniques or themes. And it's that combination that breaks down people, innocent people included. Confrontation scares the defendant into thinking it's futile to maintain innocence, and minimization makes the defendant or suspect conclude that confessing won't be that bad. And if you reach those 2 conclusions taken together just as a basic cost-benefit analysis, you'll conclude that confessing might be your best way out.
Doctor, when you answer any more questions, can you slow down for at least me? I don't know about the jurors, but just so we all understand your testimony.
My apologies.
No
Yes.
problem, no problem. Doctor, is it the combination of these 2 tactics that contribute to false confessions?
Yes.
And the 2 tactics are?
Confrontation and minimization.
And how do we know that?
So there are a number of ways. First, we've done a great deal of looking at, analyzing cases where we know the confession was false, proven false confessions. And we see the Reid method used in many of these cases. Secondly, there are a few laboratory experiments which reproduce this result. And third, and I think this is crucial, there is a literature on basic principles of decision-making applied to this area. And once we get past our intuition that an innocent person wouldn't confess, and we understand these basic decision-making principles, I've alluded to them, but I'd be happy to repeat them, it actually makes perfect sense that in some circumstances an innocent person would confess.
And why do you say that?
So, as I said, I alluded to this earlier, but I know it's an unusual concept.
Slowly, please, slowly.
Slowly indeed. If you are led to believe that maintaining your innocence is futile, it's not getting you anywhere, the interrogators lead you to believe no one's going to believe you, that is simply not a viable path. And then you are simultaneously led to believe that if you confess, things will be okay. Just think about it. If you actually maintain those two beliefs, it makes all the sense in the world that you're going to confess.
But how can someone that's innocent think he's better off by confessing to, let's say, a serious crime, something he didn't do?
So this is not a decision-making, a cost-benefit analysis or decision-making process made under ideal or even normal circumstances. These are made under circumstances deliberately designed to make a suspect feel anxious, stressful, and eventually desperate.
Would like a small 6x8 interrogation room without windows be such a tactic?
Isolating the suspect in a small, windowless interrogation room is very common as part of the Reid technique.
Are academics the only people who maintain that the Reid method contributes to false confessions?
No, a few years ago, a very interesting development. One of the leading interrogation training schools, a competitor of Reid's, Wicklander and Zulawski, who taught a variation of the Reid method, stopped doing so. And they publicly announced that they would no longer teach the Reid method because they realized it was contributing to false confessions.
Overall.
Doctor, let's turn to the case that you're here for. When I retained you, what did I ask you to do?
To assess the materials, especially the interrogations, the videotaped interrogations of the defendant, and to give you my assessment.
Okay. And to make...
Most specifically as to whether problematic tactics had been used.
Thank you. And to make that assessment, what materials did you look at?
Primarily, the videotaped interrogations. I've also read a psychological report.
Did I ask you when I retained you to give me a certain opinion?
Of course not, and if you had, I would have hung up. You asked me to give you an honest assessment.
And what is your assessment?
The officers in the July 20th interrogation of the defendant used a very aggressive version of the Reid technique.
Can you explain that to the jury?
So right at the outset, they told Skylar that with medical scientific certainty, her account where the baby was stillborn was false. That is standard confrontation. And then they advanced any number of minimization themes. They led on that the main purpose of this interrogation was a burial for the baby, a proper burial. They told her that they knew she didn't harm the baby deliberately. They said that she had been alone and in shock. These are all fairly typical minimization themes, but they went beyond that. They made two statements that I found particularly problematic. Lieutenant Fain said to her, "It's not as if we're suddenly going to jump up and judge you and say you're going to jail." And Detective Carter said to her, "You just tell us everything and then we can move on." Both of these comments indicate that the suspect will receive zero punishment if she confesses. Not a light sentence, not a benign treatment, but zero punishment. And that is an extreme and particularly troubling minimization tactic.
That's it problematic, in your view, for what reason?
Because it can break down an innocent person and lead him or her to confess.
I need to approach again, Judge, I apologize. Professor Hirsch, in the interrogation of Skylar, and I believe I'm referring to the second interrogation, July 20th, was there anything in particular about that interrogation that bothered you? And I'm referring to gurgle, the word gurgle. Can you?
Yes.
And what's troubling about that?
It's a subset of a broader phenomenon where there were several examples where Skylar seemed to echo language or information that had been given to her by the interrogators, and that's perhaps the most obvious example. Lieutenant Fain suggested to her more than once, "The baby gurgled, did the baby gurgle?" which is a somewhat unusual notion, at least to me, and later on, Skylar says, "The baby gurgled." And we find this in many cases of proven false confessions. We see instances where the suspect has basically spat back information or ideas that were supplied by law enforcement.
You said that you're not a psychologist and you do not evaluate defendants to determine their particular susceptibility. Is that correct?
That's correct.
But are you familiar with the literature that tells us about the susceptibility of certain populations or types of people?
Yes, I am.
Can you summarize that for us, please?
There are certain populations.
Go ahead and answer.
Thank you, Your Honor. There are certain populations, young people are among them, people with mental illness are among them, that are particularly susceptible. They're overrepresented in the universe of false confessors. And there are certain individuals who are suggestible. That's what they're called. They can be evaluated for this. They're deemed particularly prone to be broken down.
By authority figures?
By authority figures, even if innocent.
You indicated earlier that you read Dr. Bassman's psychological evaluation of the defendant.
Yes, I did.
Was there anything you found significant in that?
I think you might want to rephrase your question, Mr. Richards.
Let me approach for 1 second, Judge.
Mr. Rickers, you may continue.
Your Honor, based on what we discussed at the bench and the court's previous parameters, I'm finished with Professor Hirsch.
Counsel, cross.
One moment, Your Honor. Good afternoon, sir.
Good afternoon.
You would agree with me that the Reid technique that you're talking about, it produces reliable confessions. Is that
As
fair?
well as unreliable. Yeah, what I tell people is the problem.
My question was just, you would agree with me that it produces reliable confessions. Is that correct?
Some of them, yes.
Okay. And I think you would agree with me, but you never want to look at a suspect's statement by itself. You would want to look at that and look at all of the surrounding circumstances of the offense itself to determine whether you can believe the statements in that the suspect may be making or not believe them. Is that fair to say?
Yes,
You want to look at all of the circumstances surrounding the offense,
absolutely.
including the suspect's actions leading up to the offense. You would agree with me?
I'd say all the evidence in a case is relevant,
Actions during the time of the offense,
of course.
actions after the offense.
That could be relevant.
You want to take all of that into consideration when you're looking at whether the statements made by a suspect may be true or not true. Is that fair to say?
Yes, it is.
Okay. With respect to your point about minimization, when you're talking about the confrontation and then the minimization, you would agree with me that with respect to minimization, there are times that people actually want to confess or say something that they know that they did wrong, but because they may be afraid of the consequence, that may be prohibiting them from feeling like they can tell the truth. You would agree with that statement, is that correct?
Yes, I hope I could elaborate on an answer I gave you earlier that's also germane to that question.
Mr. Hirsch? Professor Hirsch, if Mr. Knippen asks you a yes or no question, he gets a yes or no answer.
Fair enough, thank you, Your
All
Honor.
right, go ahead, Mr. Knippen.
Could you repeat the question, please?
Sure, it was that with respect to minimization, there are times that people want to say something that they did, but because of the consequences that they think they may face, they may be reluctant to do that. Is that fair to say?
If I'm limited to yes or no, yes.
And minimization can help put them at ease with that if they can then not focus on the consequences, but just saying what they want to say. Is that fair?
I'm stuck with yes or no?
Yes, sir.
Yes.
Okay.
Fair, I think it's a little misleading to leave it there.
Mr. Rickers can ask you any questions. Thank you, sir.
Mr. Rickers,
Let me have 1 minute.
you may.
I don't remember the exact wording, but you wanted to expound upon a yes or no question. Could you tell the jury what that question was and what you want to expound upon, please?
Yes, I think there were a few questions eliciting that minimization can be an effective technique in that it and the Reid method more broadly can produce reliable confessions. And that's certainly true. Not every use of the Reid method produces a false confession, thank goodness. What I tell people is the problem with the Reid method is not that it's ineffective. The problem is that it's too effective. It does break down some guilty defendants, for sure, or suspects, but it also breaks down some innocent suspects.
I have no further questions.
Anything else for this witness?
No, Your Honor.
Thank you, Professor. You can step down.
Thank you.
Are we done for the day, or do we have one more witness we can get on?
Judge, we could call maybe even more than one if that's okay with the court.
Okay. Jury said they could be here till 5:30, so we got 22 minutes.
Okay. Leanna Lyons. You want me to grab her? And Your Honor, you shared with the TV about no video for certain people.
Is this one of these?
She is not one of those, but some of the other people are.
Okay.
Raise your right hand. Do you solemnly swear or affirm that the testimony you will give in these proceedings to be the truth, the whole truth, and nothing but the truth, so help you God?
So I apologize, Mr. Rickers. Is this one of our witnesses who do not wish to be photographed?
She's okay with photographs.
Okay. All right, you may proceed.
Leanna, can you please state your name and spell your last for the record?
My name is Leanna Lyons. It's spelled Leanna-Lyons.
And how old are you, Leanna?
I am 25.
25 years old. That, if you scoot a little closer to the microphone, it might pick you up as well. Where'd you go to high school?
I went to Franklin High School.
All right. And did you get further education?
Yes.
Where?
Miami University of Middletown.
What do you do now, currently?
I currently work at VRI. We monitor medical alert buttons. I am a customer service representative.
And where do you live?
I live in Franklin.
Do you remember when you first met Skylar?
Yes.
When was that?
At church, when we were younger, I'd probably say early mid 2000s.
Back when you saw, what church?
The Franklin Vineyard.
Did you have a relationship at that point?
No.
Did you guys, to your recollection, ever even talk back then?
No, not really.
Later in life, did you have an occasion to meet Skylar again?
Yes.
When?
When we worked at the Atrium YMCA.
Okay, and the Atrium YMCA, can you explain to the jury what you did there and what the program was?
We worked in a drop-off daycare, meaning while the parents would work out, we would care for their children, ages 6 weeks to 10, 12 years.
And how long, do you remember when you started?
Yes.
When was that?
October of 2014.
And how long were you there?
I was there until February of 2018.
Okay. And you're what, 5 years older than Skylar?
Mm-hmm.
Do you remember when Skylar, approximately, when she started working there?
Yes.
When was that?
I would think about 2016
Okay, and do you remember how long she worked there?
until 2017.
So about how long, I know this is easy, but about how long did you work with Skylar?
6, 8 months. It wasn't very long.
Okay. How often, how many days a week were you with her?
About 3 to 4 days a week.
How old was she at the time, do you know?
16 or just barely 17.
And I had in my notes, Skylar started in the summer of 2016, right before her senior year, that'd be about right?
Yes.
And the last date that she worked there would have been, do you remember an incident? Like, was it the interrogation?
Was it July?
So about
July,
a year.
yes.
Does that sound right?
Yes.
So Skylar was 17 or 18, would have made you 22, 23?
Mm-hmm. Yes.
During work, did you guys have an occasion to speak at all when you guys worked together?
Yes.
How many children would be in child watch at any given time? What would be the range?
The lightest amount of children, maybe none to 1 or 2 children, to about 23.
And how many women did you work with?
There would be 3 of us staffed.
Okay. And by the way, did you and Skylar hang out socially?
No, never outside of work.
Have you ever hung out with Skylar outside of work?
No.
And Skylar hasn't worked there for over 2 years?
Correct.
Okay. When you worked with her for those 10 to 12 months and saw her 3 to 4 times a week, did you have an ability to form an opinion regarding how she interacted with children?
Yes.
And did you have an ability to form an opinion as to how she interacted with human beings, other coworkers,
Yes.
and parents?
Yes.
What, if you could describe Skylar's character for us, from what you saw with her interacting with children, what would that be?
Very kind, very sweet, very naive.
Why do you say naive?
There were things that I would talk about with the other coworkers, and maybe I'd go back and re-explain it, or naive just as she has not been exposed to the things that I have.
Young-ish?
Yes.
Was there ever an occasion where you wanted to kill an animal, an insect? And can you tell us that story?
I wouldn't kill it. There was a bug in our front window. I called up to the front desk. They would not go back and kill it. They told me that I had to. So I decided to stay away from it. When Skylar got to work that day, I asked her if she would kill it, and she just scooped it up in a little cup and took it outside and released it.
How many you worked there for 4 to 5 years, right?
Mm-hmm.
And about how many teenagers or women did you work with?
Probably about 10.
How did Skylar stack up among the ladies that you worked with in terms of her ability to interact and connect with children?
Really well. I'd put her up there with one of the better teachers that we have.
Were there any children that would make any expressions to you that would indicate that they wanted Skylar and that was it when they got there?
Yes.
And how so?
When this child was younger, he would always sleep. She would hold him while he fell asleep, and he got attached to her that way.
Was there a child that would cry if Skylar wasn't working?
Yes.
And do you remember how old that child was?
I believe he was 3.
Do you remember Skylar stopped working in July when she was charged in this case. Do you remember in February, March, or April, or May any signs of pregnancy that you saw when she worked with you?
No.
What did she wear to work? Was it the same for everyone?
Mm-hmm.
I'm going to show you what's been marked as Defendant's Exhibit 0031. Is this the t-shirt that was essentially issued, right, for you ladies?
Yes.
And when was this taken, if you know?
Easter.
How do you know?
The rabbit.
Sorry. You were not in this picture.
I was not.
Okay. Is this what most of the ladies wore, and Skylar would wear workout leggings and a t-shirt? Did she ever change that workout leggings and t-shirt while you worked with her?
Maybe a different color T-shirt, but we were told to wear purple, but those shirts don't hold up very well, so we would always get different colored ones as replacements.
You know what Skylar's charged with in this case?
Yes.
Is she capable of hurting another human being?
No.
I have no further questions, Your Honor.
Mr. Knippen, Ms. Kraft, you may inquire.
Thank you.
Good afternoon, ma'am. So through her work at Atrium, is that right? Atrium Y?
Mm-hmm.
Skylar has been around all kinds of different babies, is that correct?
Yes.
Babies as young as 6 weeks old. I'm assuming some of those are big babies, some of those are medium-sized babies, and some of those are small babies. Is that fair to say?
Yes.
So she has been around all types of babies and knows the different sizes of babies. Is that accurate?
Yes.
Okay. When you were working with her, you didn't know that she was pregnant, is that right?
That is correct.
And you didn't know that she was actively concealing her pregnancy, did you?
No, I did not.
And you didn't know that at the time that she had given birth in the middle of the night, alone, and then taken that baby and buried it out in the backyard, did you?
I had no clue, nothing had happened.
When you learned of that, when you saw, I'm assuming you probably saw it on the news, is that fair to say?
When she was first arrested, yes.
Were you shocked to know that?
Yes.
Why were you shocked?
Because the Skylar that I know would not do that.
So would you have even been able to fathom or consider that she would have had the ability to conceal a baby, deliver it in the middle of the night, and then bury that baby in the backyard? Would you have even been able to fathom that from Skylar?
Never.
So is it fair to say that we don't always know what people are capable of?
The Skylar I know would not do that, and I firmly believe that. So,
And I understand that. And I understand that you're saying she would never hurt another human being. But the Skylar you know, can you imagine her, forget whether she murdered her baby or not, can you imagine her giving birth alone in the middle of the night and taking this lifeless body out to the backyard and burying it? Can you imagine that from the Skylar that you know?
I could not imagine that from anyone, no.
Thank you.
Anything else for this witness? Thank you, ma'am. You can step down. Ladies and gentlemen, I think we are going to call it a night for the evening. Remember the things that you're free to go, ma'am. Remember the things that I have previously told you. All of those things still apply. Do not begin thinking about how this case should be decided. Do not begin discussing the case amongst yourselves. Do not let any of the people at home discuss the case with you or in your presence. Do not read any media accounts about this. No internet research on your own. Don't go to Professor Hirsch's website. Just take what we give you as the evidence and don't do any homework on this on your own. We will plan on starting tomorrow morning, again at 9 o'clock. We seem to be settled into a pretty good pattern. We get here by 8:45 and we start at 9 o'clock. Mr. Mullins, you can take the jury out. You may be seated. We are on the record outside the presence of the jury. We probably should take this opportunity to talk about some objections that were made during the testimony this afternoon. Ms. Kraft, you wanted to make a record about your objections concerning playing the tape of Dr. Andrew to Dr. White.
Yes, Your Honor. I think that there was testimony that he considered everything that he thought was relevant to the case. I had questioned him on whether or not he had been provided with those and asked if the information that was in there would have been something he would have liked to have known. He indicated yes. I asked at that time if I could play those so that he could determine whether or not the information contained within those would have changed his opinion in any way.
Mr. Rickers, I think that you wanted to place on the record some of the questions that you wanted to ask Professor Hirsch that I would not permit and proffer those answers.
Judge, I'm satisfied with what you allowed in, and I'm not going to make any further objection.
Okay, so no proffer?
No proffer.
All right, anything else we need to do today?
Judge, there's a state fire marshal report that the state gave us as part of the discovery. It's base stamp 272. They did not call Detective Carter to the stand, and Lieutenant Fain testified that he was aware of it, but I don't think I asked him if it was a fair and accurate depiction and presented it. The state is refusing to agree to the authenticity, so we might have to call the state fire marshal down here and have them come when they're available to authenticate what they gave us in discovery, because we want the jury to have it.
Okay. Any reason not to talk about some housekeeping issues now that we're finished?
Housekeeping in terms of,
Scheduling for tomorrow?
oh, no, that's fine.
Okay. All right, let's take about a 5-minute break, and if you need longer than that, that's fine. Why don't we reconvene here, and you can make your way through here. The jury's gone by now, so you can make your way back to me. I know Mr. Mullins is doing his cleanup, so as long as you're together, you can make your way back to me. All right, we'll see everybody back here tomorrow at 8:45 with the idea of starting at 9 o'clock. We're in recess.